we would like to call the meeting to order. And would like to know if there's any adjustment or addition to the agenda. And a motion to approve the agenda as presented. All in favor, say aye. Agenda approved. Thank you. You also had a copy of the minutes of our last meeting of June 13, 2023. Like to entertain a motion to approve those.
Second.
All in favor, say aye.
Aye.
Thank you. And it's approved. Next, public comment. Did anybody sign up for public comment? No. That's a simple one. Then next, new business. And first of all, are there any board members that have an conflict of interest with the subject property owner, or the applicant? No. All right. Then I only have to read this one. This is a quasi-judicial evidentiary hearing. It's like a court hearing. North Carolina state law sets specific procedures and rules concerning how this board must make its decision. These rules are different from other types of land use decisions like rezoning cases. The board's discretion is limited. The board must base its decision only upon competent, material, relevant, and substantial evidence in the record. A quasi-judicial decision is not a popularity contest whereby opinions are considered. It is a decision constrained by the standards in the Mills River Code of Ordinances and based on the facts presented. If you will be speaking, please focus on the facts and ordinance standards, not personal preference or opinion. Participation in this hearing is limited. This meeting is open to the public. Everyone is welcome to watch. Parties with standing have rights to participate fully in the hearing. Parties may present evidence, call witnesses, make legal arguments. Parties are limited to the applicant, the town of Mills River, and individuals who can prove they will suffer special damages as a result of this decision. Other individuals may serve as witnesses when called on by the board. Witness testimony should be limited to facts, not opinions. General public comment is not permitted during the hearing. All witnesses must swear or affirm their testimony, and in one moment, the clerk will administer oath for all individuals who intend to act as a witness or provide testimony. Then I would like to have a motion of the evidentiary hearing 2302 Development Partners LLC request for special use permit in Mills River General Business located at 510 Lucky Drive in 963267561 and Sharp Road in 933609288 to use the property for a shopping center containing a grocery store with drive-through pharmacy and drive-through restaurants, in addition to the by right permitted uses in the general business MRTD zoning district. All in favor, say aye. In the hearing, I guess I read this already, the announcement of the special use permit application. The special knowledge we've addressed already of the board members. Recognition of any person wishing to petition the board to act as a party with standing. Who is here to present the case? Nobody? Okay. All those here to present evidence, we need to swear those in. Then next we. And please look here.
Mr. Chairman, I think you also need to inquire about any personal knowledge that they may have acquired about this prior to this hearing, so that can be put on the record.
Okay, I did.
Did he? Okay, I
Yep.
missed it then. I apologize.
Thank you. Good evening. As it's been announced tonight, we're going to hear a minor special use permit application from Harris Development Partners, acting as an agent for the James Good Revocable Trust, who's the current owner of the subject property. Again, the request is for a minor special use permit to use the property for a shopping center with a grocery store, pharmacy drive-through, and drive-through restaurants, in addition to the permitted uses by right in general business. Minor special use permits require the approval of the Mills River Board of Adjustment per town code. In your packets, you have Town Zoning Code 154.057B. This is the section on the general business zoning district that lists the permitted uses and the uses requiring a minor special use permit. You'll see shopping centers and drive-through restaurants are listed in this section. And then it also identifies that commercial uses not otherwise named herein, which come within the spirit and intent of this district, subject to a finding of the Board of Adjustment, that both the conditions and definitions of special use are met, are also allowed with a minor special use permit. So just a little background. The general business district is meant to be, and this is a quote from the ordinance, provide a place for offices, personal services, and the retailing of durable and convenience goods for the community. Districts are located on major thoroughfares, collector streets, and because these commercial uses are subject to public view and are important to the economy of the community, they shall have ample parking, controlled traffic movement, and suitable landscaping. Just reviewing the application submitted, the applicant claims, and these are the two standards needed to issue a minor special use permit. The applicant claims the proposed use will not adversely affect the health and safety of persons in the area because the proposed uses are permissible in the general business-based zoning district and are consistent and compatible with surrounding uses and the designated uses in the Making Mills River future land use map. The applicant also claims on the application the proposed uses will not be detrimental to the public welfare or injurious to nearby property or public improvements, because all local, state, and federal regulations will be followed in the construction and occupancy of the shopping center and related uses. In your packets tonight, before I go any further, we have the minor special use permit application and associated materials from the applicant as attachment A. We have a very general vicinity map, aerial view of the property as attachment B. We have the general business zoning ordinance excerpt that I just read through as attachment C. There's a conceptual site plan for the development as attachment D. You have your comprehensive future land use map excerpts, the first one of the map, the second for the land use categories as attachments E and F, and then the certificate of mailing public notice letters as attachment G. And while I'm on that, I might as well state that the hearing was properly noticed tonight. We sent public notice letters to all neighboring property owners on September 19th and posted a public notice sign that same day. And then there were legal advertisements in the Hendersonville Lightning on September 27th and October 4th. And those are the items that I'd like to submit into the record. I won't go through all of this now, but if the board pays attention to the last page and a half of your packet, these are the minor special use permit requirements that must be met in order for the board to issue a minor special use permit. The first two are the most important. And again, I read through these, but I'll just read through it again. Number one, the proposed use will not adversely affect the health and safety of persons residing or working in the neighborhood of the proposed use. And then two, the proposed use will not be detrimental to the public welfare or injurious to property or public improvements in the neighborhood. Per our ordinance, if the applicant or the board feels the applicant meets these standards, the minor special use permit shall be issued. There are additional special use permit standards on the following pages of the staff report. These can be used to attach conditions to an approval if that's the way the board goes. And again, they address ingress and egress to the property, transportation safety. Number 4, provision of off-street parking, addresses noise, glare, odor effects of the use. Number 5, we covered this one, but use shall be located or developed in a manner so as to comply with all regulations. Number 6, establishments requiring a special use permit shall be located and developed to be consistent with an official thoroughfare plan. Number 7, establishments requiring a special use shall be located and developed in a manner to minimize environmental impacts, surface water, wetlands, groundwater. Number 8 is the availability of utilities. Number 9 is buffering. Number 10, open spaces, landscaping, pedestrian ways, etc. And then number 11, building and structures with reference to location, size, and use. So if the board feels the applicant is not meeting one of these additional standards, the board can, in theory, attach a condition when we get to that point. But I just wanted to summarize that before we get into the hearing. And again, the attachments in the staff report are all I have to submit into the public record at this time.
We agree with the planning and zoning director's exhibits and presentation.
You can come up.
Good evening, members of the board. My name is Asa Harris with Harris Development Partners. Development special use permit application. Appreciate the planning director's thorough presentation. All of his findings. The evidence for you meets the 2 general requirements along with all the supplementary requirements that have been discussed. I thought this one was already on. Okay, does that work now? Good. Okay. So, first and foremost, we feel that the proposed individual uses here that are part of the shopping center are already permissible in the current zoning district. So the reason we're here tonight for the special use permit is because we want to have a shopping center functioning as one complete entity, with connectivity, being cohesive architecturally, landscaping, lighting. We end up with a much better, superior development with having one cohesive development versus 5 separate developments that are permitted by right in general business. In addition, management of these under one versus management of 5 different properties, we'll find long-term provides great benefit. At the end of the day, in addition to that, we don't feel that, there's any way this is going to adversely impact the health and safety of residents, but will actually be improved, I think, over separately developed general business properties. We also provided a draft TIA where we are mitigating all of the traffic impacts of the development through improvements at each of the major intersections, through turn lanes, signal improvements, signal timing, and the such. So all of that being said, that's really the extent of what we have to present, but certainly would welcome any questions.
I would like to ask, and I'll ask Mr. Malachek if this is an appropriate question and, Mr. McKellar, you'd agree. I'd like to ask about the lighting. I noticed that one of the conditions is to minimize the glare. We don't currently have a lighting ordinance in Mills River. We are discussing that as far as making sure that all the lights are full cutoff and not just the typical wall packs that blast out light everywhere. Is that something that I could ask if it would be considered, or?
That would be appropriate. If you look under the regulations, number 4, it's pretty clearly speaks to glare and dust and lighting. So
Yes,
that
sir.
would be appropriate.
So that's one of the concerns I would have. Is it going to be lighting up the world out there, or keep the light, on the premises as much as possible?
And I believe this one is on, or Larry, if you prefer, I go back. up.
No, sir, you stay there. It's fine
Oh.
with me.
So 100%, we are agreeable to full cutoff fixtures. That's something customarily we would do. In addition to 0-foot candles
Yes, sir.
at the property line with the residential. We know that there's a new ordinance that's coming into effect, that's not yet binding, but certainly a condition for full cutoff fixtures and no light trespass, against residential properties is
Yes, sir.
something we would welcome.
Thank you, sir. Appreciate that.
Absolutely.
Any other questions at this time? You need to recognize any other person that's saying that, just to don't have anybody to, or who doesn't do that. Recognition of any other person wishing to make any public comment. And public comment is not considered expert testimony and cannot be a basis for court decision. Still want to give that opportunity.
That's at the chair's discretion. So in the past, in the Board of Adjustment hearings, the chair has allowed public comment. But again, just with the note that we're giving the public an opportunity to be heard in a public meeting, but that the board members can't use this in their decision making. But correct, Mr. McKellar.
Can't say it any better.
Preliminary discussion. For the board. Practice, like, now, I didn't see the original. Know what the studies are based on? Yeah.
Yeah, it appears that the counts were taken in 2023. We don't have in the appendices, it would have the actual count data you could look at, but typically it's either taken in the year that is shown here, or it's previous year's counts that have been grown by a certain percentage, the approved growth rate to get to this year. Since COVID is pretty much most of the effects, those are gone. The 2023 data should be pretty accurate. Sir. And I'm a traffic engineer, full disclosure, and I'm trying really hard not to get very deep into this. And I would ask Mr. Malachek, for the record, that NCDOT, once this is sealed and is submitted to NCDOT, it will be reviewed by them and then determined if it is correct and complete. And then any recommendations in here will be binding as part of the driveway permit and the zoning permit.
That's correct.
Thank you.
You brought up a good point, at least for me, because this is the first time I've had time to read it, and I hate to sit here under the table trying to read it, so y'all don't think I don't know what I'm doing. My question is, and I just got it, DOT hasn't come back on this report, if I'm hearing you correctly.
No, ma'am, they won't have seen it yet because it's
Right.
not sealed.
And so if we go ahead and grant what is asked, and then we want to put in some other things that we wish, anything we put in on the traffic really isn't going to be pertinent at this point. Or the traffic improvements, because no one knows, DOT is going to have the final word on it, I'm assuming.
And I would think they would. I don't think that we as a board can get really deep into the traffic requirements because.
Right.
Yeah, and plus DOT has to approve it or not. And then they may come back with something that's not in here that they would say, okay, well, you got this turn lane at 225 feet. It needs to be 250 feet. Or they may say that something about one of the signals or something. So
So even if we said A, B, and C, if DOT says, well, that's nice, but really D, E, and F is what it should be, then it's going to end up being D, E, and F. Am I correct?
ma'am, because they've got, NCDOT has the sole jurisdiction over the roads.
Got it. Thank you.
Sure.
But we can put more restrictions on. Conditions that we can add.
That's correct. Those are some of the conditions that you have the authority to add. You can say must comply with whatever the DOT approval is, plus orange side curbs or whatever you decide is appropriate.
Any other questions? Discussion? Then I think we can close our preliminary study. And,
If you could do that by motion and vote, please.
yes, I would like to thank motion to close the evidence portion of the. All in favor, say aye.
Aye.
There no on page and. Considering all the factors set out before the. Yeah. Liberation and making with the fact. And this is that. Basically. Attachment, Mr. Muhammad, the proposed findings of fact, those related to the case.
No, so there are no draft findings of fact, and the board will have to make their own findings with your attorney's help. Again, based on the numbered items on the second and third page of your staff report. So if you want to use that as your cheat sheet of what to go through, those numbered items are the specific items the ordinance points out.
Well. So for every of these 11 points, we will have to make a finding.
No, not every point.
Okay.
The first two are the requirements for issuing a special use permit. You have to find that it's not going to be adverse and that it's not going to be detrimental or injurious. Those are required findings to issue a special use permit. If you want to put any special conditions in addition to, then you would need to find at least the finding of fact related to that special condition. You don't have to find, for instance, just for example, that satisfactory ingress and egress to the property of proposed structures with particular reference establish that this shall be located or developed in such a manner not to seriously worsen traffic congestion by compliance with DOT regulations or input, something along those lines. But you could make a finding of fact that specifically finds why you've made an additional requirement on the special use permit, if that makes sense.
Yeah, but we don't have to make a finding of fact that they have to fit the DOT requirement. That's outside of our.
That's correct. That is something that would be done anyway. You could make the finding that this establishment shall be located and developed in such a manner as to comply with all applicable federal, state, and local laws, rules, and regulations, and then make that a requirement. That would be a possible finding of fact as well, just to sort of complete your permit.
Ready? And we have to what the specific reasons for these findings of facts, or is it just for the state that the proposed use will not adversely affect this area?
It would need to be something along the lines of, based on the evidence presented, the sworn testimony and evidence presented in this hearing, the proposed use will not adversely affect the health and safety of persons residing, working in the neighborhood of the proposed use. That might be the first finding of fact. Next one would be the proposed use will not be detrimental, and so on.
Do we need a finding of fact saying that it was properly noticed and?
That
Is
has
that a good
been,
thing?
has been announced in here. I think that would be a good finding of fact as well. Yes. It's properly noticed and
I make a motion that we determine as a finding of fact that this evidentiary hearing was properly noticed, that public notice letters were mailed to adjacent property owners, the date given, public notice signs were posted in multiple locations, and legal advertisements were ran in Hendersonville Lightning on the dates mentioned.
All in favor, say aye.
Aye.
Motion carries.
Make a motion. Hearing no evidence to the contrary, I make a motion that the proposed use will not adversely affect the health and safety of persons residing or working in the neighborhood of the proposed use.
And I'll second.
All in favor, say aye.
Aye.
Motion carries.
Make a second motion. Hearing no evidence to the contrary, I make a motion that the proposed use will not be detrimental to the public welfare, or injurious to property or public improvements in the neighborhood.
Favor, say aye.
Aye.
Aye. Motion carries.
And I'll make a motion that as a finding of fact, hearing no evidence to the contrary, satisfactory ingress and egress to the property and proposed structures thereon with particular reference to automotive / pedestrian safety and convenience of traffic flow and control has been given. Establishments, this establishment has not been located or developed in such a manner to seriously worsen traffic congestion so as to endanger public safety, and that is pending NCDOT's and the town's review of the traffic impact analysis.
All in favor, say aye. Motion carries.
For number 4, provisions of street parking loading areas will require with particular attention to ingress and egress to the property, economic noise. So we put a condition, which they've already spoken to, that they will use, lighting. So what's your vote?
Full cutoff or, yes, cut off lighting that minimizes glare. Yeah.
If that is cut off lighting. All in favor, say aye.
Aye. I'll make a motion that absence of evidence to the contrary, this establishment has been located or will be developed in such a manner as to comply with all applicable federal, state, and local laws, rules, and regulations.
All in favor, say aye.
Aye.
Motion carried.
And I'll make another motion as a finding of fact that in absence of evidence to the contrary, this development will be located and developed in such a manner as to be consistent with any approved official thoroughfare plans. Aye. I mean, I don't want to be greedy
Oh,
with these.
we don't have to do that.
Okay,
Don't have.
okay. Just want to make sure that we're good on all of them.
I would like to. Go. I'd like to, put a condition that where it can be placed, that that there's a fence, green space, and trees and that kind of thing. It's consistent with, I just want to make sure it's green space. Just disregard, I'll worry about it. Okay. Any other? Form of the motion. Yes, I have a. Make the motion that we approve the minor special use permit, supplement C3-02. That met conditions, we approve the minor special use permit.
May I just to clarify, because would that be subject to the condition that there be non-glare cutoff lighting?
Yeah, we've already made that motion.
That was in the findings of fact, but you're now to approve, you want to make sure you put a condition on that approval that's specific.
Then I will amend the motion to also add that we approve this minor special use permit with condition they use, reduce display, shut off light, or the other. And then we approve it. Second. All in favor? Aye.
Aye.
Motion carries, and the minor special use permit as with the additional condition is approved as I would like to say motion to close and adjourn our evidentiary hearing.
Aye.
Excuse me, Mr. Chairman, we did not hear who's made the motion to close the hearing? We heard several
I
people
made the
second.
motion. I made the motion.
You made the motion.
Yeah. I don't do that. Excuse me. Next, announcement, our next regular scheduled meeting in December 12th. And. Yeah.
Aye.
35 minutes.